Think your severance package is just a nice goodbye check? Think again. Behind that friendly offer might be legal landmines that could wreck your career or cost you thousands. Hi, I'm Tom Spiggle, employment lawyer and founder of the Spiggle Law Firm, and I'm here to show you how to spot the traps your employer hopes you will miss. You just got laid off. HR hands you a severance agreement. You're upset, anxious, and they're telling you you need to sign this quickly to get paid. But slow down, because that document might include some really sneaky clauses that could hurt you later. Let's start with the basics. What is a severance package? A severance package is what an employer offers you when they terminate your employment. It often includes a lump sum or continued pay for a set number of weeks. Sounds good, right? But here's the catch. You only get that money if you agree to their terms, and those terms can include things that are not in your best interest. Let me walk you through some of the most common traps I see in these agreements. Number one, non-compete clauses. You think you're getting a payout to hold you over until your next job, but buried in the fine print, a non-compete clause that bans you from working in your field for a year or more. In 2024, we saw the FTC attempt to ban non-compete agreements, but unfortunately, these efforts were blocked by courts in Texas and Florida. However, that doesn't mean your state doesn't have some regulations against them. Be sure to check your state-specific laws on non-competes before signing any papers. Number two, non-disparagement clauses that gag you forever. These clauses say you can't say anything negative about your former employer, not to a recruiter, a journalist, or even a future boss. That's not something you want on your shoulders after leaving a bad situation. Release of claims. This is a huge one. When you sign a severance agreement, you're usually giving up your right to sue. Even if the company discriminated against you, retaliated, or broke the law, you're signing that right away. And guess what? I've seen cases where the severance offer was pennies compared to what the person could have won in court. Now, those are some of the things your employer may try to hide, but you might be wondering, how can they hide such obvious traps? Well, here are some ways they might attempt to confuse you. They may bury the problematic clauses, like non-competes or waivers, in dense, complex legal language. Their goal is to overwhelm or confuse the employee just enough to sign without reading closely or consulting a lawyer. For example, they might write something like, the employee hereby irrevocably waives and releases all known and unknown claims, including but not limited to those arising under Title VII, hoping the language is complex so that you won't understand what they are making you sign. Another strategy is artificially short deadlines. They give you a tight window, sometimes just 48 or 72 hours to review and sign. This creates panic and urgency, so you don't take time to fully read or seek legal advice. They might say something like, you have until Friday at 5 p.m. to accept this offer, or it's off the table. Next is the false, quote, this is standard language assurance. HR may tell you, oh, that's just boilerplate, nothing to worry about. They downplay your concerns and discourage you from asking questions or pushing back. They might make the severance money conditional on you accepting all terms, non-compete, waiver of claims, non-disparagement, etc. This makes it feel like all or nothing, even if the trade-off isn't fair. Some agreements reference other documents, like company policy handbook, or tuck critical terms into footnotes or definitions. They are counting on you not reading the fine print or cross-referencing linked materials. Non-disparagement and confidentiality clauses often have no expiration date, preventing you from speaking out even years later. Their strategy is to silence whistleblowers and criticism forever. And lastly, they use broad or undefined terms like confidential information, competitor, or affiliated entities. Their intentionally vague language leaves room to accuse you of violations later when they decide you've said or done something they don't like. Here's an example for you. A former tech employee signed a severance with a vague no future employment clause, only to find out it barred him from applying to any company the parent company had a stake in. He unknowingly blacklisted himself from dozens of employers. So here's what I want you to remember. Never sign a severance agreement without reading it carefully, and preferably having a lawyer look at it. Don't be pressured by deadlines. That sign in 3 days or lose everything tactic is designed to make you panic. Take your time and don't panic. And finally, ask questions. You're allowed to negotiate. You can push back on the non-compete or ask for more money. If you've been offered a severance package or think one might be coming, talk to an employment attorney first. It could make the difference between a clean exit and months of legal headaches. At the Spiggle Law Firm, we have extensive experience helping clients get the severance they deserve and avoid the traps their employers try to hide. Visit SpiggleLaw.com to book a consultation with our firm today, and be sure to subscribe to our page for more insights on employment law.